weaponize all the stuff I have in my favor, and they don't want me to get it before the court because they don't want me to win. See, it's not about justice. It's about upholding the statistic.
What if the person deciding whether you live or die was secretly working with the people trying to convict you? Not figuratively, not ethically, literally. For nearly 20 years, one man sat on Texas death row, waiting for the state to execute him, until the justice system discovered something so disturbing, it erased his conviction entirely. No new DNA, no confession, no surprise witness, just a hidden relationship that never should have existed. So the question isn't whether Clinton Young committed a crime. The question is far more unsettling. Can a death sentence ever be trusted when the trial itself was never fair? In the early 2000s, Clinton Lee Young was a teenager growing up in Texas. By the time most people are choosing colleges or first jobs, Clinton Young was standing in a courtroom, accused of capital murder. The charges stemmed from a violent crime spree in 2001 that ended in the deaths of 2 men. Prosecutors alleged that Young was a participant, someone who not only took part, but deserved the harshest punishment the state could impose. At trial, the case against him relied heavily on co-defendant testimony, a type of evidence that legal experts have warned about for decades, testimony from someone who has everything to gain and often a deal on the table. Still, in 2003, a Texas jury convicted Clinton Young of capital murder. The sentence, death. He was just 18 years old. From that moment on, Clinton Young entered a world few ever escape: Texas death row, a concrete cell, endless appeals, and a calendar that slowly counts down to execution. If you were convicted at 18 based largely on another defendant's word, would you trust the system that condemned you?
But you've been here for a long time, right?
Yeah, I've been here since 2003. I was 19 when I came to death row. I was 18 when I got the case, right?
And you're now?
30.
30.
Yeah, I just turned 30 in July. It's kind of a depressing milestone.
I would have said congratulations, but it's not really.
That's what I say. It was kind of a depressing milestone. I mean, at one point I didn't think I was going to make it to 30. Mm-hmm. You know, and now that I made it, it's like, well, I've spent all my 20s on death row, so.
If you want deep dive documentaries that examine the system, not just the crime, subscribe now. These stories matter, and they disappear when no one is watching. Clinton Young did not stand trial alone. Alongside him were 3 other men, all charged in connection with the same crime spree, all facing serious prison time, all with powerful incentives to survive the system. And when the pressure mounted, they did the one thing prosecutors rely on more than any physical evidence. They pointed at Clinton Young. In court, each of the other defendants accused Young of being the shooter, the person who pulled the trigger. Their testimonies became the backbone of the state's case. But there was a problem. Each of those men stood to gain something by testifying: reduced charges, lighter sentences, a chance to avoid death row themselves. This is known in the legal world as incentivized testimony, and it has played a role in some of the most infamous wrongful convictions in American history, because when freedom is on the table, the truth can become negotiable. The jury was told these men were witnesses. What they were not fully shown was how much each one had to gain. If 3 people accuse the same man, but all 3 benefit from doing so, how much weight should their words carry?
And then JR comes from around the house and he gets kind of like real close to Doe's car by walking around, and then that's when Clinton Young shot him.
And Clint walked over to the body and pulled out the pillow, put it back over his head, and pulled the trigger again, and he ran around to the front of the car and got back in and told us to get in.
What makes this even more unsettling is what came later. Over time, the stories told by these men shifted. Details changed, timelines blurred. Key facts contradicted one another. Defense attorneys would later argue that the case against Clinton Young was less about proving guilt and more about choosing who would carry the blame. Someone had to be the trigger man, and Clinton Young became that person. Not because the evidence demanded it, but because the narrative required it. This context matters, because when Clinton Young was sentenced to death, it wasn't based on DNA, fingerprints, or a confession. It was based largely on the words of three men trying to save themselves. And when you combine that with what we now know about the judge-prosecutor conflict, the foundation of the original verdict becomes deeply unstable. If you're finding yourself questioning how often testimony like this decides life or death, subscribe. These cases don't just expose crimes, they expose systems. Death row is not just a sentence, it is a condition. In Texas, inmates on death row live in near total isolation. 23 hours a day inside a cell the size of a bathroom. Meals through a slot. Human contact reduced to echoes through steel doors. For Clinton Young, years passed like this. Appeals were filed, motions denied, execution dates loomed and were pushed back. Every time the phone rang, every time footsteps approached his cell, every time the state updated its schedule. This is where most death row stories end. But this one didn't. Because buried deep inside the record of Clinton Young's trial was something no defense attorney had noticed, something no appeals court had addressed, something that, once uncovered, would change everything.
It's no excuse, but my defense is I didn't kill nobody. I didn't know nobody was going to die, and nobody was supposed to die. You know, we was going to go buy some blunts, marijuana cigars, you know, and then things took a turn. The guy got shot, and then at that point, I was worried about getting in trouble.
At the center of every criminal trial are three key forces: the prosecution, the defense, and the judge. The judge is supposed to be neutral, a referee, a safeguard. But in Clinton Young's trial, that neutrality did not exist. Years after his conviction, it was discovered that one of the prosecutors in Young's case was also employed by the presiding judge, serving as his law clerk at the same time. Let that sink in. The person helping the judge research cases and draft legal opinions was also helping the state secure a death sentence against the defendant standing before him. This relationship was never disclosed to the defense, never explained to the jury, never revealed to the public. Legal experts later described it as an unconstitutional conflict of interest, one that fundamentally undermined the fairness of the trial. The system had failed at its most basic level, not because of bias that could be argued, but because of a relationship that should never have existed at all. If the referee works for one team, is the game still legitimate?
So they offered you a plea deal.
Yes, ma'am.
For how many years?
I think it was either like 60 or 65.
60 or 65?
Yeah.
And how did that feel to you?
I'm like, for what? I came, I told y'all what I knew about both murders.
So first they offered you 60?
Yes, ma'am.
And then they, at one point, offered you 30, right?
Yes, ma'am.
It didn't feel right?
No, it didn't feel right at all.
Because you've helped them, right?
I figured you help me, I help you.
Mm-hmm.
This is where the criminality of the state's actions come in, because they're bound by Supreme Court law. I mean, it's the law of the land. If you make a plea bargain, you have to inform the defense. Mm-hmm. When I go into that trial, I'm allowed to know everything that's going on. My lawyers had a hearing before the trial and put the district attorneys on the stand under oath and asked them, has there been any talks of plea bargains?
And they said no.
They all said no. Okay, well, we got that report. The new attorneys I did, they get the lawyer's personal file, mm-hmm. and that's how they got this report. And so they go get the attorney's billing records that he's filed with the courthouse to get his money. Mm-hmm. And on almost every line is met with district attorney and client to discuss plea bargain. Met with district attorney. It's like 5 lines.
Where is everybody sitting in the car? Doyle's under the wheel, obviously.
Doyle's on the wheel. And I was in the middle at the time, in the middle. And Mark was right here, and JR was on the other side, the left side of me, in the back seat.
So this is the seats here. When you get to the house, does everybody just stay sitting in the car?
Yeah, it stayed seated for a while until JR went out there and went around the house.
So JR gets out and why is he walking around the house? Do you know?
They're supposed to buy weed.
Okay, all right, from this house. So this guy living in this house. So JR gets out and walks around the house, right? And so that leaves the three of y'all and Doyle sitting in the car. What happens then?
And then JR comes from around the house and he gets kind of like real close to Doe's car by walking around, and then that's when Clint Young shot him.
And David Page was standing outside the car walking up to the car when he shot him.
David Page shot him?
Yes, that's what I'm saying. The window was rolled down and things like that. When he hit him, your natural reflexes, Doyle set back up and fell forward, and that's when Page shot him in the back of the head. And then I jumped out the car.
So what you're saying is that JR is somewhere outside this car over here? Where was JR standing when Clint?
He was standing right in front by the door.
He's standing there when Clint, any conversation, I mean, you're sitting almost right behind him. What conversation's going on in the car right before and during the time that Clint shoots Doyle? What happened?
Okay, before he was sitting Clint was sitting at a slant way like this, and he had the gun up under him like this, and when he was going to shoot him, Doyle was paying attention to JR, and JR reached and opened up the door. As soon as JR reached and opened up the door, Clint went and shot him.
Okay, so what did Clint say anything when he did it?
He says, "Sorry, Doyle," and then just shot him.
He said, "Sorry, Doyle," and then shot him? Okay.
You're going to voluntarily then tell us what happened out here, where everybody was, in regards to that. Is that correct?
Yes, sir.
Okay. This is the little road where the body was found.
So we just stepped back, and Clint walked over to the body and folded up the pillow and put it back over his head and pulled the trigger again, and he ran around to the front of the car and got back in and told us to get in. And JR got back in the front.
How many times did he pull the trigger?
He pulled the trigger once again.
Okay,
So
how's the body laying?
the body was laying like long ways in the
Okay,
creek.
face up, face down on the
It was
sidewalk.
face down. He told us to lay it face down. And when we were driving off, he told me and Nene and them that if we said anything to anybody, that he'd kill us and our families.
Were any of you armed?
Clint was armed. Mark Ray was armed. And JR.
What were they armed with?
2 22s and a 38.
Who had what? You remember?
Clint had a 22.
Describe it.
It was chrome with a long nose on it.
And it was 22 caliber. You're sure of that?
Oh, I know it was a 22.
Okay.
And they had another one like a revolver. It was a 22 short
Who
black.
had it?
And the 38
Who
was
had the 22, the short black 22?
the short black 22, Mark Ray.
And then there was another gun you said. Who had it?
The 38 was in possession of it was in possession of me.
You had it.
If this case is already changing how you think about the justice system, take a moment to like the video. It helps these stories reach people who need to hear them. In 2021, nearly 20 years after Clinton Young was sentenced to die, the Texas Court of Criminal Appeals made a stunning decision. They overturned his conviction, not reduced, not modified, vacated. The court ruled that the undisclosed relationship between the judge and prosecutor had so tainted the proceedings that Young had been denied a fair trial. For the first time in 2 decades, Clinton Young was no longer a condemned man. He was removed from death row. Eventually, he was released on bond, walking free while prosecutors decided whether to try the case again. It was a moment that raised uncomfortable questions. How many other cases had similar conflicts? How many were never discovered? And how many people never lived long enough for the truth to come out? When Texas retried Clinton Young, the facts did not vanish. The same crime, the same deaths, many of the same accusations. Once again, the case leaned heavily on testimony, stories told by men who had been there, men who had already spoken once before. But this time, something fundamental was different: the process. There was no undisclosed relationship between judge and prosecutor, no hidden conflict operating behind the bench, no structural advantage quietly steering the trial toward death. This retrial was not about discovering new truth. It was about testing old testimony in a courtroom that finally followed the rules. And when the verdict came back, it told a quieter story than the first trial. Clinton Young was convicted again, but the death penalty was taken off the table. The same words, a different process, a different outcome. That contrast is impossible to ignore, because if testimony alone were enough to justify execution, the result would have been the same. But it wasn't. What changed was not the accusation, it was the system evaluating it. If identical testimony leads to a life sentence under fair conditions, should it ever have led to death in the first place?
How likely is it, because the two co-defendants who did a lot of less time, they said that Clinton was sitting here, pulled his gun from his waistband and shot him twice in the head. How likely is that from that? Is it possible?
Not just pulling and shooting, no.
Can you show me how that would...
You'd have to do this number right here, and if you shot from right here,
Yeah?
there's no way.
Where would you hit me if I do this?
Probably wouldn't even hit you.
Because?
It'd probably miss you, because you're not aiming.
On this distance, you
from
can
this
still
distance.
miss?
Yes. If you just pull out and do like this,
Yeah.
you can miss this person. Trying to shoot the head, the body you could hit. The head is harder to hit.
Because it's moving, right?
But if he was, yes, if he got shot in the head twice and kind of close, the bullet holes were kind of close, there's no way he could have just pulled it out and shot like that.
Because that's what they said. They pulled it out of his waistband, kept it there, and shot him from that point on this side of the head.
Was he an expert shooter?
No, he was 18. No.
Okay, there's no way he could have shot like that and hit the person twice in the head.
Because you have to be an expert?
You'd have to do a lot of training. And at 18 years old, there's no way he could have done it. There's no possible way. Because bullets do not shoot around a corner.
If this distinction between evidence and procedure matters to you, make your voice part of the conversation. These issues only change when people stay engaged. Before this story ends, there is one final dilemma that cannot be avoided. Some will say this: Clinton Young was convicted twice. A jury believed the testimony twice, and a life sentence proves the system ultimately worked. Others will say something very different, that once the process is corrupted, no outcome can ever fully restore legitimacy, that a death sentence imposed under unfair conditions leaves a permanent stain, even if corrected later. So here is the question that divides people more than guilt or innocence. If a man survives death row only because misconduct is exposed, not because new evidence emerges, does that mean justice was delayed, or that it was almost lost forever? There is no easy answer, and where you land on it says more about how you view power, punishment, and trust than it does about Clinton Young himself.
These are the two options that could have happened.
Yes.
I'm gonna need your vehicle. Pow, pow. Okay?
And where do I fall from that?
From here, you would fall this way. That
Okay.
way.
So that doesn't make sense.
It doesn't make sense there. Okay?
No.
The other one is, if I'm getting in the vehicle and you're turning to do whatever you gotta
I
do to the
was doing
seat,
this. Yes.
he gets over right here. Pow, pow.
So that's what happened.
And what's gonna happen? You're gonna fall this way.
Like this.
Yep.
And this is what happened. This is what they said. I'm not sure
Because
if
if I'm
he...
getting in the vehicle, pow, pow. I need your vehicle. Pow, pow.
And then I'm not sure if he fell like this or like this, but he fell
He fell towards it. Was he
toward
probably
the
in
steering wheel.
Yeah. So is this guy right here getting in?
This was him.
This guy getting in
It's
right
the
here.
only option.
Yeah, if he fell forward, this guy right here shot him. Pow, pow. He went forward. He was getting in the vehicle.
Yes.
That's the only way. If this guy was leaning forward on the steering wheel, he was getting in the vehicle and got shot from inside the vehicle.
And that's what they all say, that he was getting in the vehicle when the shots were fired.
Then he done it.
But they said he did it. And he said, I didn't see it because I was just getting in the vehicle.
Because he's the one that done it. This guy was the one that done it. Getting in the vehicle.
Only option.
That's the only person that could have shot him. They ramrodded that guy. It's the guy getting in the vehicle was the one that shot him.
That's David Page.
That's the only one that could have done it.
Hold on.
And can we remove the dog?
You said it's a two-door car, right?
Mm-hmm.
Okay, so he may have been leaning forward.
Yeah, he was actually.
So you would need to be like back here a little bit.
Yeah, so yeah.
So you would need to be a little bit.
That's uncomfortable anyway. All right, we ready?
Yes, but the dog is still there.
Should be all right. It's going that up way anyway. Like this here.
No. Did you hit it in the shoulder?
In the shoulder.
And one of the co-defendants said he was actually aiming from 20 centimeters off. Then you can hit him in the left
No.
with your left hand then.
Yeah.
Then you should have to.
You'd have to reach around like this, where this guy is. Oh, here, hold the gun, shoot him.
Can you? Well, maybe you can go that side without.
Well, you'd have to lean back,
Yeah.
and then those two guys back here are going to say,
Yes.
"What are you doing?"
But why would a jury believe this if it seems so clear to us?
Prosecutor. If the prosecutor has a good story, he can get the people to believe it. Now the defendant, his attorney's got to be real good to counteract that. Apparently he didn't have a good attorney.
No, he didn't. No.
So that's if you don't have a good attorney, most of the time you lose anyway.
Clinton Young's case is not just about one man, it's about process. The death penalty assumes perfection in a system run by humans who make mistakes, hold conflicts, and sometimes hide them. In this case, the system came within months, perhaps weeks, of executing a man whose trial never met constitutional standards. And if this conflict hadn't been discovered, Clinton Young would be dead, no retrial, no correction, no second look, just a closed case and a quiet file. So the real question isn't whether Clinton Young is innocent or guilty. The real question is this: how many similar errors are still buried in cases where no one is looking anymore? Should a system capable of making mistakes like this ever be trusted with the power to kill? Share this video if you believe accountability matters more than outcomes. The system only changes when people are paying attention.